The Court of Appeal has declared Section 22 and 23 of the Computer Misuse and Cybercrimes Act 2018 unconstitutional. Justices Patrick Kiage, Aggrey, Muchelule and Weldon, Korir further warned that the judiciary must be alive and alert to the risk that the act can be deployed for political purposes, calling for careful scrutiny of every application before granting any order. Ayub Abdikadir reports.
A three-judge bench of the Court of Appeal found Sections 22 and 23 of the Computer Misuse and Cybercrimes Act of 2018 unconstitutional, in the awarding ruling that they were too broad to the extent that they are likely to net innocent persons. Section 23 of the Act seeks to punish any person who publishes false or fictitious data or misinforms with the intention of passing off the data as authentic. It prescribes a maximum fine of 5 million Kenya shillings or a 2-year jail term or both. The section also seeks to limit Article 33 of the Constitution on the freedom of expression, where there is intentional publication of false, misleading or fictitious information likely to propagate war, incite persons to violence, constitutes hate speech or advocates hate. While Section 23 of the Act deals with knowingly publishing information that is false in print, broadcast, data or over a computer system, calculated to or resulting in panic, chaos or violence among citizens, and attract a 5 million Kenya shillings fine or a maximum of 10 years in jail or both. The High Court in 2020, 2 years after President Uhuru Kenyatta signed the bill into law, dismissed a case by the Bloggers Association of Kenya, the umbrella body that challenged the constitutionality of the act, leading the association to file an appeal. In the 5 grounds they outlined for determination, Justices Aggrey, Muchelule, Patrick Kiage and Weldon, Korir found all the other grounds of the appeal by the bloggers umbrella without merit. Alive to the risks posed to expression owing to politics and governance, the 3 judges of the Court of Appeal recommended in the course of the implementation of the Act, courts and other institutions of the state to pay attention to offence for which an interception order is sought, the period of interception, how data is examined, used, stored and protected from third parties, and provide for the eventual erasure or destruction of the digital evidence.
But now you know that the person who...
A month after the Gen Z-led demonstrations in 2024, Wajir East lawmaker Adan Dawood introduced amendments to the 2018 Act, prompting public outcry. Petitioners, among them the Kenya Human Rights Commission, mounting legal challenge over the changes signed into law by President William Ruto in October 2025, terming them punitive and posing the risk of shrinking the country's democratic space. The ruling comes as a reprieve for Kenya's connected, urban and youthful population, whose governance discourse on social media spaces has seen them bearing the brunt of abductions and extrajudicial killings. Ayub Abdikadir, Citizen TV.